We're going to start talking about the specifics of copyright law. And the first point we have to talk about is the subject matter. What sorts of works are subject to copyright? Just think of some off the top of your head, right? You might be sitting at your desk and there's a book, right? Hopefully you're not watching a movie at the same time as you're listening to the lecture, but movies, songs, computer programs, your diary, finger paintings, poems, blueprints. These are all subject plus some. I mean, those are just a few examples. We'll talk about the actual statutory categories. So, copyright casts a big net. It can apply to a whole lot of works. And we are the definition. I'm citing that 17 USC 102 capital letter A is the statutory number for copyright law, the section that we're going to talk about. So if you're interested in actually looking, I paraphrase some of these. Some of them I'll quote exactly the language as we go along. If you're following along, you want to go to the code. There's a link for Moodle, on Moodle for it, where you can click to the actual Copyright Act and find this section number. So what it says is copyright applies to any original work of authorship fixed in a tangible medium of expression. So when we're dealing with a work that we want to determine whether or not it's subject to copyright protection, we're looking or asking ourselves these three questions. Well, does it qualify? What qualifies as a work of authorship is what we're going to address. But does a work qualify as a work of authorship? And we'll talk about what that is. What does it take to meet the originality requirement? It has to be original work of authorship, and it has to be fixed in some sort of tangible medium. If we have all of those things, then the copyright protection is triggered. But we have to meet all of those things, so we have to kind of define what constitutes a work of authorship. And it is a broadly construed or defined. The law could have limited works. The law could have said it's only for fine art. Remember when we were talking about the history? Originally it was only for books, and then it went to maps and charts and books, and it started to expand over time. So yeah, the law could have just kept it to fine art or high quality literary merit. They could have, limited categories to novels, short stories, poems, paintings. It could have included genres like fiction and history and documentaries, and leaving out others like risque works or comic books or detective novels. It could have been argued or reasoned that because copyright confers a bundle of exclusive rights, that only a certain works deserving those rights should be copyrighted. And that could be measured on grounds of aesthetic merit or social value. But we don't have any of those things. It doesn't have to be of high quality. It doesn't have to be from a specific genre. And it doesn't have to meet any sort of social value or aesthetic merit. I show you this. You may recognize one of these pictures. The one that looks like an evening night there to the right-hand side of the screen, if you're facing the screen, is Van Gogh's Starry, Starry Night. The other side, awesome piece of work, is something I painted at some friend's paint and sip thing. But both of these qualify for copyright protection. It's not because that's a Van Gogh masterpiece and that's a Rebecca Fox 1 hour trying to copy the picture onto a canvas. As you can see, I have limited artistic skills. But nonetheless, my doodle on a napkin, right? My poem that I wrote in my journal the other day. these things could qualify for copyright protection. So there's no requirement with regards to it having to be of some standard of quality. And one of the cases, and it's an old case, I think I gave you the heads up that we'll be talking about lots of old cases, because that's how these laws start. Remember our precedent? A court makes a decision, and if it's good law, it's going to stay with us because a judge is going to continue. The courts that have to review the issue are going to continue to uphold precedent. So this case is from 1903. And what happened here was the plaintiff had created these advertisements. These are advertisements for a circus. Let's say the one on the bottom is nicely colored. And what happened was the defendant, Donaldson, used those particular posters, in something that he was working on. It's not specific in the case. And the plaintiff sued. They sued saying that's copyright protected. That's our work. And the argument that the defendant made was those aren't protected by copyrights. They're just ads. That's an advertisement. It's not like it's some great work of art that you put together. And the court said that no, in fact, advertisements are worthy of copyright protection. And if we think about that today, ad agencies, right? Look at the ads for products that we have nowadays. If those weren't protected by copyright, they'd be copied left and right, to use that phrase. So obviously this is still good law. And the point of this was to try and flush out what was going to be acceptable. And now, mind you, this is a case from 1903, and from our introductory discussion on copyrights, our act has gone through several changes. The act from 1909 wasn't even in place. So this was in the category of like the maps, the charts, the books, where the Supreme Court made this decision about advertisement. And that's still our law today. But think about what the purpose was. The purpose of the Constitution of copyright was to provide an incentive to create works. An incentive to create works. Do we think the statute takes that approach? If we don't have copyrights, many of these works won't be produced. Who would produce works if there wasn't any protection? What would happen? No one would want to create anything, like a movie that cost millions of dollars to make. If others were free to copy it and distribute it, it'd be hard for the producers to make any money, let alone a profit. They wouldn't be able to make their money back. So, reasons why people create is to make money, but there are folks who don't. There's some who would put their works right in the public domain. Professors like to write, and their works go into a public domain. They'll sometimes put them in. People just want recognition. You write a letter, even if you wrote a letter to your grandmother or another relative or somebody else, that's subject to copyright protection. So advertisements, as I said, clients pay for the creation of ads. What about magazine covers? What's the purpose of that? What's the purpose of magazine covers? People magazine, big picture of Brad Pitt on the front. It's to attract customers. Does it qualify to hang in an art gallery? Probably not. So it's got a commercial character to it. Does that take it out of copyright protection? No, a cover design could qualify. Reader's Digest, actually, if you're familiar with the Reader's Digest magazine. If not, Google it. You'll be able to see a picture of it. It's a very small, unique sized magazine cover, and their cover is protected. There's no other magazine that can do that size and shape. There's some that try. They might go a little slightly bigger. Oh no, we're not copying. But Reader's Digest has a copyright on their style of magazine. So the first thing here to qualify is works of authorship. Of course, we have two other to meet, but I think we have to talk about what falls outside the category of works of authorship. So what might fall outside of works of authorship? How about conversations? Witty remarks, practical jokes, children playing, crime spree. How about a tantrum? These are all kind of fruits from human creativity, right? You see any problem with that? Those might be hard to police. There's kind of a little guidance of what would that constitute a work in that regards. How about a soccer game? A basketball game? Who would be the author? How about a football playbook? Now that might qualify, because what do we have? We have plays or scenes drawn out in a book. How about a dance routine? Scripted. That could be. How about a video game? Video of a soccer game, newspaper article of a soccer game. Now those two could constitute a work of authorship that would allow for copyright protection. Of course, they have to meet the other two elements we haven't gotten to yet. We're just talking about works of authorship. This case involving the estate of Hemingway versus Random House. Very interesting set of facts. The young man, well, let me tell you what the issue was. It was a Supreme Court case. No, actually, I'm sorry. It was the New York Court of Appeals, the highest court in New York State, ruled on this one in 1968. Whether conversations of a gifted, highly regarded writer may become the subject of copyright, even though the speaker himself had not reduced his words to writing. So here, Mr. Hemingway had a traveling companion, and his name was Mr. Notch. And during that time, they hung out and had conversations, and Ernest Hemingway would discuss, and reminisce and have literary opinions and reveal comments about actual people and about that his fictional characters were based on. And Mr. Hotchner, that's his name, Hotchner. If I said it wrong before, it's Hotchner. He was taking notes of these conversations right after they occurred, or he would record some of them. And after Ernest Hemingway passed away, he wrote and published several articles about these conversations. And the estate of Hemingway sued, saying that those were protected. He's a renowned writer. He's given, much of the information regarding his inside knowledge on his books and his opinion and, with regards to literary works. So she sued for copyright infringement. She argued that she's entitled to the copyright on the theory that by directly quoting the comments, stories, and opinions of Hemingway's literary creations, that the defendant was note-taking and recording it, this was protected. And then the defendant said that argued that Hemingway never suggested to him or anyone else to regard his comments as literary works. They were just conversation. So, Mr. Hemingway's words protected? No. Speech and conduct not copyrightable. Remarks are not considered literature for purposes of the copyright. Unless somebody says explicitly that they are. But that would raise other issues coming down the pipe. Now, mind you, this case is older, prior to our new statute, the 1970, I call it new because that's the one we're dealing with. The latest version of the Copyright Act would have some other issues with that unless an explicit claim to the right is made, because we have this idea that something has to be fixed, and we'll talk about what fixation is probably next week. So our comments and remarks are not considered literature. They fall outside the scope of what is copyrightable. The Copyright Act itself, actually this is not this other designation, this 37 CFR Section 201, refers to the federal code. The first section that we just talked about that addressed what's copyrightable is in the Copyright Act. And this is the federal code as to, it has more guidance as to what is on certain issues that come up. And in this instance, what we're talking about is what's not a work of authorship. There's also a link to that in Moodle as well. So you have access to all of these statutes here. So what it says is copyright is not available for words, short phrases such as names, titles, and slogans. What do we save those for? Possibly trademark slogans, right? Short phrases if it's a slogan. But generally, words, short phrases, names, titles, and slogans are not copyrightable. Does that make kind of sense? What if you could copyright a title? No one could ever use it again. How many titles do we know of various books and songs that have the same title, right? Best of My Love. There's the Eagles and the Emotions, two different songs, right? A song title, one, Three Dog Night, Metallica, U2, all three different songs. Words like three-peat, copy wrong, copy left, you can't claim a copyright to mere words. But what about a compilation of short phrases? What if you took all the famous short phrases and you made a book, or you made a book of slang words? Now that might be copyrightable. Does that make sense? So let's talk about this idea of an author. What does that mean? Does it say anything to you when you hear the word author, work of authorship? Does it imply anything? Like who or what is the author? Does it need to be human? Does it need to be human? I believe there's an appearance that it means that the work was human created, using some sort of requisite creativity. So think about things like a security camera mounted in a lobby 24/7 that captures a dramatic event. Is that a copyrighted video? Generated works raise an issue. Those things that are generated automatically. There's experiments going on with AI, artificial intelligence creating programming. Lava that flows from volcanoes, forming fantastical shapes. A piece of driftwood, even if you polish it up and hang it on a wall, not copyrightable. None of those things that I have referenced are copyrightable. The key is must have human involvement. And the Copyright Office actually has interpreted that statute to mean to be registered as a work, it must be the product of human authorship. But it wouldn't be a authorship discussion without me telling you about the monkey. Because this is a fun case. And it's in the book, too. The story's in the book. This photographer, famous wildlife photographer, was in Africa taking pictures of this particular type of monkey. And the fancy name for the monkey escapes me at the moment. And what happened was there was like a group of them, and the monkeys were kind of hanging out, and he had several cameras kind of set up. He was taking pictures at different ones, and this guy picked up one of the cameras and clicked it just right and captured this photo. So this monkey here took a selfie with the camera, and the guy thought it was the best ever. There's actually a series of pretty funny pictures that this monkey was just clicking away and caught some pretty good pictures. So the photographer published them along with the story. And then what happens is PETA, the animal protection group there, stepped in and sued him. What's PETA? People for the Ethical Treatment of Animals, PETA. They stepped in and they brought a lawsuit claiming copyright infringement on behalf of that photographer, saying he doesn't own the copyright in that photo. He shouldn't be out selling it. It belongs to the monkey. And this lawsuit was in the state of California. It went all the way up to the highest court in California, federal court in California, before any sort of resolution happened. And oddly enough, the court kept it around. Actually, the court dismissed the case. The lower court dismissed the case, and PETA appealed, and they still lost at the appellate. But then they filed another appeal up to the highest level court, federal court in California. And this poor photographer is like, I don't have the money to like keep going on and on and on with this lawsuit. But PETA's argument was that clearly the monkey understood that he took the photo, because like so many other animals, he's highly intelligent, thinking, sophisticated being worthy of having legal ownership of their own IP rights. Now, I don't know how they actually made that argument in court without laughing, because the question begs, well, who's going to actually take care of the money that any of the money that the picture makes, right? PETA. Anyway, the case settled with the photographer going, I can't take any more of this. And what happened was they agreed, they made an agreement. He gets to keep the photo. The photographer gets to keep the photo. His legal bills were a lot more expensive than what he made on the picture. But the deal that was made was he'd get to keep the picture, and any money that came of it would be donated to an animal charity. I mean, he didn't even say he'd give it to PETA. He just said an animal charity, and apparently that made PETA happy, and the case settled and was resolved. So the key here is that you need a human involvement. And like I said earlier, before I started talking about the monkey case, is you have to have a human involvement, and the Copyright Office has interpreted that to be a registered work that must be the product of human authorship. And there's also begs the question that we're going to get to is works by mechanical process or random selection without any human contribution. And those are the AI issues. But we also have issues dealing with cameras, right? Cameras, recording devices, and should those be treated any differently? Should those be treated like conversations? I mean, we can record anything at an instant notice. Does it need to be automatic? Those are some questions that are going to come up along the way. So our test here is showing that someone set out to create the work. If that's what we're trying to hang our hat on of what's human involvement, we have to show that someone set out to create the work, and that's going to be our test as we move forward. Now, one more point I want to make before we move into the categories. Something else that is not a work of authorship, a person's identity, not a work of authorship. Lady Gaga, Madonna, Michael Jordan, they can't go out and get copyrights on themselves. They've tried, people have tried. While they might argue that they created their persona is personality, character, likeness, but it's other things too. It's genetic makeup, it's experiences, influence of other people, and it's kind of hard to take that and then fix it into a tangible medium, unless the argument is it's my body. But no, the persona and identity, not works of authorship. But what if they take their personality, character, likeness, genetic makeup, experiences, and influences, and put them into an autobiography or self-portrait? Those could be copyrighted, but their identity themselves, no. And Lady Gaga can't copyright her name, Lady Gaga. And Madonna can't copyright her name, nor Michael Jordan, because names are not protected. So our takeaway here is not everyday conversations and behavior, even if recorded randomly, words, short phrases, works with no human author, and no identity or persona can be deemed a work of authorship. Okay? So we are going to switch to the categories of work set forth in the copyright statute.